Good afternoon, everyone. Thank you so much for attending the latest entry in Bressler's webinar series. We really have a great audience here today to discuss some regulatory updates and best practices as they pertain to senior and vulnerable investors. This is a familiar topic if you've attended some of our other webinar series, and I think we'll put an interesting spin on it. I hope we'll put an interesting spin on it for you and give you some good takeaways to move forward. On our panel today, we have myself, Joelle Sims, who's a principal in Bressler's Texas office, Kristen Standifer from the Washington Securities Division, Carolyn Mendelson from Hardin Compliance Consulting, and Rochelle Truzzi from Hardin Compliance Consulting. To introduce myself, I've been part of Bressler's financial institutions practice group for the past 7+ years and have been dedicated to our seniors and vulnerable investor group since it started a number of years ago. And I am primarily responsible for the Bressler Senior Map, which we'll discuss in a little bit, and which I'm sure that many of the attendees have seen. Joelle?
Hi, everyone. For those of you that don't know me, my name is Joelle Sims. I'm a principal in our Dallas, Texas, and Fort Lauderdale, Florida offices. I am in our financial institutions group as well, focusing primarily on the representation of financial institutions, registered reps, investment advisors, in customer disputes as well as employment disputes. I also do commercial and employment litigation as well. And I co-chair our firm's senior and vulnerable investor group. So this is an issue very near and dear to my heart that I enjoy speaking about. So looking forward to speaking with my fellow panelists and hearing what the audience would like to hear about today as well.
Hi there, I'm Kristen Standifer, a licensing and examination supervisor for the Washington State Securities Division. I'm the vice chair of NASA's Senior Issues Committee and also the chair of NASA's Broker-Dealer Market Regulatory Policy and Procedure Project Group. Prior to coming to the Securities Division, I worked at the Washington State Attorney General's office, where as a part of my duties, I litigated issues relating to financial exploitation of seniors. This is also a topic that is very near and dear to me as well, and I'm really excited to be here presenting with this great panel.
Hello there from Hardin Compliance. My name is Carolyn Mendelson, and we are a team of over 30 consultants who put together customized compliance programs for securities firms to address issues like this. And prior to coming to Hardin, I was in a similar seat to Kristen for about 14 years and very active on some NASA committees that Kristen has mentioned as well. So it's a pleasure to be here, and thank you for having us to Bressler.
Yes, good morning. My name is Rochelle Truzzi. I am also from Hardin Compliance Consulting, and very excited to be here today. So thank you so much for the invitation to participate on the panel. I've spent a number of years, all of my career actually, in the securities industry, and half of that has been with Hardin Compliance Consulting, serving broker-dealers and investment advisors from big corporations to the sole proprietor. Mainly my focus is FINRA, the broker-dealer side, but I've had the privilege of working with the investment advisors, mutual fund companies, and the whole gamut in the industry. So I'm looking forward to today's discussion. Thank you.
Thanks, everyone. And to kick us off, Kristen, if you could talk a little bit about what you see and why do you think this is a growing issue?
Sure. I mean, the number of seniors in the United States is increasing and will continue to do so for quite some time. It's predicted that by about 2030, approximately 20% of the US population will be 65 or older. And we see that baby boomers control approximately 70% of the nation's disposable income, and their financial assets will peak at $26 trillion in 2029. While financial exploitation doesn't just target seniors, there's about 26 trillion reasons why it would. And we see that seniors are losing billions of dollars to financial exploitation each year. as I just mentioned, seniors are losing billions of dollars each year, and financial exploitation is on the rise. This graph emphasizes that point really clearly. In the 20-year period between 1990 and 2010, there was about a 29% increase in financial exploitation of seniors. And it's predicted that in the next 20-year period between 2010 and 2030, financial exploitation will increase by 81%.
And I think another thing worth mentioning here is a lot of times it's hard to pinpoint the exact amount of money lost each year, because a lot of these incidents go unreported, and we'll talk about it later, but a lot of these incidents happen between family members and people get embarrassed to say something. So this is likely a bigger problem than the numbers indicate. Joelle, could you talk a little bit about the SARS filings?
Yeah, absolutely. And so kind of to that point, I mean, there's not really a lot of great ways to track this because it's dependent upon disclosure and reporting. And so one way that we sort of can track this, and that is interesting statistically, is looking at SARS filings, suspicious activity report filings. And so these are just by securities firms. You can also, this does not include reports by banks, credit unions, and those types of entities, which frankly often see much more of this than the securities firms. But the category of elder financial exploitation, or EFE, showed up in 2012. And you can see that since 2012, the annual reports in which firms checked that box has just increased lockstep every single year, including through 2020. So this is something that's continuing to happen, something that's happening with more frequency as predicted by the last graph we just saw.
So we know that this is a growing issue, Carolyn. So, we know the diminished capacity case, or the people with diminished capacity, are rising. Why is this a concern for brokerage firms?
Sure. This is a concern not just from a social policy perspective, because it leads into a lot of other social issues if seniors do not have command and control of their funds, or people with diminished capacity do not have access to their funds because they're gone, right? Someone has taken them. But more subtle issues are the issues of fixed income and the inability for those seniors to be able to replace the principals in their accounts. Seniors have high income needs, and with a flat market on the bond side, it's difficult. So fraud on top of that doesn't help. Seniors also generally have a little bit of an issue, perhaps, in terms of understanding who they're speaking with, right? Who exactly is the financial advisor? It can be very confusing to someone with diminished capacity or a vulnerable person. Our RAND studies from the past point that out. So folks are already coming into this a little bit confused about which financial professional is going to assist them with what, and who is licensed exactly to do what. It doesn't help as well that there can be some technology barriers for seniors and diminished capacity individuals, in that we're putting more and more information online. We're not having face-to-face conversations, especially during COVID. And the technology is hard for folks to manipulate at times. So another issue that we're concerned about is generational planning, right? When money's taken, there's no opportunity for the rest of the family to work with that senior and to provide for important things like educations and basic needs. So there's a lot that goes on in this age category, or in this mental situation that a lot of folks find themselves in.
And because there's a lot going on, it's no surprise that there's a fairly complicated regulatory scheme on the federal, state, and administrative level. So we have really four categories of senior-based laws and rules. We have at the federal level, the Senior Safe Act, and this is the only uniform reporting law across all 50 states. We have APS statutes. These are long-standing reporting statutes that address broad areas of elder abuse. We have state report and hold laws. These are the newer laws that are directly targeted at broker-dealers and investment advisors. This is, as we'll discuss a little bit later, a rapidly changing landscape as more and more states either adopt or revise these laws. And we have the FINRA rules, which most people should be aware of by now. They've been effective since 2018, but FINRA is looking to make certain amendments to those rules. As far as who's protected, it's important to note that this is really a high-level overview. And as you'll see as we go through this presentation, you really need to be keyed in on the specific law that's applicable to your situation and which state law is applicable to your situation. FINRA's rules protect individuals 65 and older and individuals with diminished capacity. State laws vary. Some put the cutoff point at older individuals at 60, some at 65, some in between. We don't advocate a one-size-fits-all approach to this, but if you want to be safe, it's usually err on the lower side of the age bracket. Someone over the age of 60 should be treated as elderly. And the really difficult part here, especially for non-medical professionals, which we all are, is how to identify diminished capacity. And there's really no bright line rule here. And hopefully, we'll have some tips later that hopefully will help you in making that determination. Kristen, can you talk a little bit about the APS statutes?
Of course, and I apologize because my lawn people just showed up and are outside of my window as Murphy's Law would have it. But speaking about APS laws, all states have laws related to how and when to report elder abuse. And each statute is different. In addition to state APS laws, some states have laws within their Securities Act or provisions within their Securities Act that also allow for reporting financial exploitation of seniors. Some states require that all persons report financial exploitation, while in other states it's permitted reporting. And because of these different timeframes and protocols, as Andrew mentioned, it is sometimes difficult to keep everything straight. And if I'm being honest, I've referred to Bressler's map a few times myself when dealing with an issue in another state, just to make sure that I had the right statutory site. So I guess I can't endorse it, but I have used it myself. And then also these statutes allow for immunity when a report is made in good faith.
And Kristen, you mentioned this to on one of our calls about how firms should really look to maybe change the way they report certain instances of financial exploitation when referring to APS. Can you talk a little bit about that?
Sure. So we have a little bit of a translation issue between APS and firms, or even securities divisions for that, for that matter. APS is really looking at things as to how it impacts the person's activities of daily living. Whereas on, a firm might be putting it in terms of how it impacts the financial situation, or maybe using complex financial terms to explain what happened. And the social worker may not understand what impact that has on the individual's activities of daily living. So really, if you can translate into, how does that impact the person's ability to obtain food or pay their electric bill or change their financial situation to the detriment of the senior. I think if you're able to do that, you will more clearly communicate the issue with APS.
Yeah, and I think that's important because in many states, the APS statutes allow you to report to local agencies or sheriff's departments or whatever it may be that may be best equipped to actually protect the adult, the customer you're looking to protect.
Just one more thing, I always recommend that to report it, even if you're not required to report it to the securities division, if there is a securities account or product that's involved, to get the state securities division involved. Because sometimes we can act as the go-between with APS. There may be some confidentiality concerns that we may, where the APS might not be able to communicate back to the firm, but the securities division can do that. And then also help with the translation of the terms between APS and the firm.
That leads us nicely into the next category of state laws, which are the state financial exploitation statutes, which have been passed in different versions of which have been passed in 30 to 31 states, depending on how you count. A lot of which are based on the NASA Model Act, which I know Kristen is very familiar with. These laws are broken into three primary sections. There's reports to government agencies, disclosure to third parties, and hold provisions. The first section, reports to government agencies, it's self-explanatory, but there's either required or permissive reporting in those 30 to 31 states, and each state specifies which agencies you have to or can report to. Disclosure to third parties, that allows you to report to somebody other than the government agency, someone associated with the vulnerable adult. Different states have different laws there. Joelle, can you talk a little bit about that?
Sure. So these are changing really at a rapid clip, and getting passed. There's been ones passed even in the last 6 months in a number of states, and even states that had existing ones are revising those. So I will plug the map. Being a Bressler attorney and being able to do that, it's critical to know what is going on in the state where you are dealing with the customer. Some of these state statutes have required reporting, some are permissive, some allow holds of transactions, some are only of disbursements, some both. The permissive third-party disclosures, this is huge. And we'll talk about the trusted contact rule in a minute for those who are regulated by FINRA. For those who aren't, I still strongly recommend that you try and get a trusted contact. The third-party disclosures, there are a number of states, Texas is one of them, that allow you to reach out to any person reasonably associated with the vulnerable or senior investor, the person who you suspect is being exploited, or language similar to that effect. The reason why that's so crucial is that if you are dealing with a customer located in Texas, for example, or in another state that has this provision, and you think that there's exploitation going on, you are not limited to reaching out to the people that they have or have not designated as trusted contacts. And we'll go into the trusted contact in a moment, but sometimes there's difficulty in getting people to designate these, or sometimes the person they've designated is the one who you think is exploiting them. So looking at the state statute, you get all this information on the Bressler map. It'll tell you what the state statute allows. If you have the ability to reach out to someone else reasonably associated, that could be a family member, it can be a CPA, it can be an estate planning attorney, someone who is reasonably associated, that's going to open up a huge window of how you can deal effectively with these issues. So that's a big one. Also knowing whether there's required training provisions in order to be able to take advantage of the safe harbor in these acts. And here we have listed just a few: Washington, Nevada, New Mexico, Florida, and Connecticut. And the other thing that I would point out, I was speaking at the IAA, the Investment Advisor Conference, a few weeks ago, and some feedback I got was, which is similar to a comment we had here, which is, well, there's just so much going on and it's so confusing, and how do you keep track of it? I just follow the Senior Safe Act, and is that good enough? And the answer is no. It's not. The Senior Safe Act is similar to a lot of these statutes, but if you have a customer in a state that requires reporting, if you have a customer in a state that requires certain things, and the Senior Safe Act does not require reporting, it's permissive, you can do it, but you don't have to, well, then you're technically going to be in violation of state law. Now, whether the state is going to come down on you or not, I really can't speak to that. I don't work for any of these states. But not only is that going to create a regulatory risk for you, it's also going to create a litigation risk. Because if that ends up blowing back on the firm and you're getting sued, they're going to say, well, under this statute, you were required to report and you didn't. And that's going to be challenging if you're in an arbitration, in a lawsuit in court, and wherever the case leads to. So really important. There is a lot going on. I don't think there was also another question from the audience about, is there going to be some sort of federal sweeping uniformity here? No, I don't think there will ever be uniformity on this, because a large part of the issue goes to states' authority to delegate and endow certain, A, to even create the agencies, and B, to endow them with certain powers. So APS is different from state to state. And frankly, the securities commissions are different state to state. Some have much more authority and much more power than others do, just based on, you know, the constitutional authority delegated to them. So it's, you know, I don't see any scenario. I'd be interested in Kristen's perspective on this. I don't see any scenario where there's going to be one uniform approach to this, because I just don't, I think that would just be impossible based on how the United States is set up with state authority and autonomy.
I agree, Joelle. I mean, NASA has its Model Act, which the idea behind that was the state security commissions or divisions could enact the same act in every state. And as we see in the 28, 30 states that it's been enacted in, there are variations depending on the authority the Securities Commission has in that state or other political reasons. So hopefully there is some uniformity there as a result of the NASA Model Act, but I don't see that it's going to be uniform across the US. I don't know, Carolyn, if you have any insight into that as well, because I know you were in NASA when the Model Act was enacted.
Sure. You know, NASA, it does its best, as any outside body does, to create something that is workable, a good framework, a solid guidepost based on industry expertise, and then the character, nature, geography, politics of the state come into play, the practicality of it. So there are many states which have lower population than some of the more industrialized states. And how, you know, I think it's important to think about how these statutes can work. We're a very unique country in so many different ways. And the nice thing is that the federal Senior Safe Act brings us together, right? It brings us together and says, hey, this is a public policy issue. This is like drunk driving was in the 70s, right? This is like, this is like any social policy issue where I'm really hopeful that no matter what the laws in any particular jurisdiction state currently, that, you know, 5 years from now, we all think to ourselves, oh, of course, this is something that cannot go on, you know, and I would never get behind the wheel of a car, you know, if I were concerned that I might be intoxicated. That could do harm to someone, you know, really bring it to the forefront and put it into the public consciousness as an issue, and how we address it, you know, that we recognize it's a problem, and we're trying different techniques as a society to effectuate change. So our firms, our client firms at Hardin Compliance, are all part of that changing public conscience. And you know, it can be very localized, you know, at times in terms of how we actually resolve these issues, but it's an important one to begin thinking about at your firm. And that's all I can really say on the topic.
Andrew, Joelle, a question we received. Can you talk a little bit about where, what states we should be reporting to? For example, should we be reporting to the customer's residential state? Should we be reporting to the state in which maybe the representative assigned to the account is located? Or should we be concerned with our home state as an organization? You know, who all do we need to report to? Do we need to report to more than one?
I would say you should really start with a report to the state where the vulnerable or elder adult is located. That's the state agency that's going to have the authority the most authority to protect that vulnerable adult. So I would say that's number one. Number two, and a lot of times when there's exploitation, the exploitation is happening within the same state. Like I mentioned before, a lot of exploitation is close family members, neighbors, healthcare aides, people like that. But if you have a situation where you have exploitation that's happening over state lines, at least in my opinion, it's never a bad idea to report to multiple different agencies. Joelle mentioned every agency has different levels of power, different ability to go out and do something. Maybe the agency in the state where, or the sheriff's department in the state where the perpetrator is located has the ability to go out and stop the financial exploitation is happening, while the state where the elder adult is located drags their feet a little bit, maybe just because they're overworked and they just don't get to this particular complaint. So these are all, while these agencies I'm sure try to talk to each other, there's a lot of different ones and they all are separate. So, I would report as many places as you can, but definitely start where the vulnerable adult's located.
Yeah, and I would agree with that. I mean, you have to think, who are these laws enacted and designed to protect or to prosecute? It's the citizens of that particular state. So 100% report where the client is located. That's where the APS is going to be able to go and investigate and do things. If the financial advisor is located in Massachusetts and the client is in Florida, well, there's not a whole lot that the Massachusetts APS is going to be able to do for the client in Florida. I would also agree with Andrew. If the perpetrator, if you know the perpetrator is in another state, not like he's, off on the internet, the long lost newfound love from some other country. But if you know where the perpetrator is located, I would go ahead and report there as well, because that's where, the sheriff's department there, or the police department, or however they're categorized there, is who's going to be able to go out and prosecute that person. And I'd be interested in hearing Kristen's opinion, or any other regulators, who are tuning in. I haven't really heard of reporting in the state where the firm is based if the customer and the perpetrator are not located there. I'm not sure what authority they would really have to investigate or stop, unless the financial advisor is the one who's believed to be doing the wrongdoing. Then obviously you would report where the financial advisor is located. But interested to hear any regulators' perspectives on that.
In Washington, we're permissive reporters, not mandated reporters. So typically we receive reports when the senior is located in Washington. And I don't remember many or any reports that we've received where the representative was located in Washington, but the senior was out of state. I guess the one thought that comes to mind is, if a state has required, mandated reporting, and there's a difference between where the rep is located and where the client is located, I would go with, particularly what Joelle and Andrew said, report in as many places as possible. The state, though, where the individual is located, they're going to have an ability to go out and talk to the person in person in non-pandemic times. But sometimes those face-to-face communications with the individual can really help with having them realize that this transaction might not be in their best interest.
And before we move on from this, Joelle mentioned it briefly, but there are required training provisions under these state laws in 5 different states. I found this to be an area that's kind of difficult for firms, and whether you get in trouble for not having these specific training these specific state laws in your training modules and all that, I don't know, but there are some specific requirements in those states. So it's worth taking a look at the Bressler map, and it outlines everything that you need to know about those training requirements. The final part of these state laws that we haven't touched on totally is the ability to hold a transaction or a disbursement of securities or funds. So it's important to note here that diminished capacity alone is not enough to warrant a disbursement or a transaction hold. So if you disagree with something your customer is doing, but you don't suspect that they're being exploited, you can't use these laws to stop the customer from harming themselves. There's a key difference, a split really in these state laws between transaction and disbursement holds. And sometimes that gets a little bit confused. A disbursement is taking securities or money out of an account. A transaction would be a buy or a sell of a security. And we're seeing more states recently enacting transaction holds, although it's definitely not happening in every state. I know, Kristen, Washington only permits holds on disbursements. Is that right?
So we permit holds on transactions if it's connected to a disbursement, but not if it's just a transaction with the account not connected to disbursement.
And what do you see as the advantages or disadvantages of transaction holds maybe that aren't connected to a disbursement?
Well, I think really the advantage to a transaction hold that's not connected to a disbursement has to do with when there's a power of attorney or a third party that's managing the senior's money. Sometimes we see the third party managing the account in a way that benefits them. And they think, well, when this person passes, the account goes to me anyway, so I might as well start trading it how I want now. Whether or not that's actually suitable for the senior. So those transaction holds would protect against that, or in that situation, it would provide some, protection against adverse tax consequences if there's a low basis in a security that gets liquidated. So those are the advantages I see to the transaction holds.
And I won't spend too much more time plugging the Bressler map, but if you want a detailed overview of all of these state laws, the APS statutes, the financial exploitation statutes, along with links to where to reporting forms if they're applicable in a certain state, that's all there. It's updated regularly. I know because I do it. So it's updated regularly, and I hope you find it useful. If you have any questions about it, feel free to reach out. Joelle, can you talk a little bit about the trusted contact rule and FINRA's rules?
Yes, so the trusted contact rule, this was an amendment to 4512, which basically says that firms must make reasonable efforts to obtain the name and contact information for a trusted contact. The firm also has to disclose to the customer in writing that they're authorized to contact the trusted contact person and disclose certain information. This is probably the single most useful tool that firms have to deal with these issues. It is so important to get buy-in, and you have, for the broker dealers or people with larger offices, getting buy-in from the client-facing employees or advisors is so crucial. If an advisor sticks this in a form and a stack of 10 forms in front of a client, you are not going to get the information most of the time. This is something that you have to have a specific conversation about and say, this is what this is for. A lot of times there's confusion about, well, they think it's a POA, a power of attorney, or they think that it's going to give this person information about the assets in the account, or it's going to give them the ability to trade or make decisions, which is not true. But there has to be a discussion and there has to be buy-in on getting this information, because if not, you are not going to get it, and you're going to be in a real tough spot if you encounter exploitation. And I also would suggest get more than one trusted contact if you can, because if you have one trusted contact, then people are most likely to designate their family members. They're also most likely to be exploited by their family members. So if the trusted contact is the one doing the exploiting, then that's obviously not very helpful. You don't have to go crazy. You don't need 10 trusted contacts, but if you can get 2 or 3, I'd say you're in good shape. And people oftentimes think this is family. And when I've done field training before, I've gotten the question, well, I have a client and they don't have family, or I've got a client and they hate their family. What am I supposed to do? It doesn't have to be family. It can be a CPA. It can be, an attorney. It can be, I don't know, their doctor. I don't think most people would designate that person, but it doesn't have to be family. And I did see one comment about getting buy-in from trusted estate attorneys and elder attorneys. And, interestingly, about a year ago, I guess it was more than a year ago now, I was speaking at the Florida Bar elder law section before a bunch of T&E and estate planning attorneys on senior issues. And this was something I really hammered there and said, you got to talk about this with your client, because, and in that context, I said, because if you don't, you may end up getting named, which none of them wanted. But it's something that there really needs to be buy-in all around to get these people on the account. And we'll talk about this a little bit later, and kind of touched on it with APS with some of the comments. Most of these state statutes, the amount of time and effort it's going to take to really get to the bottom of a situation, if there's truly exploitation happening, is not going to happen in 20 or 30 days. It's just not, unless there's like some sort of lightning speed department. And so really, then the firm is in a position where, okay, maybe you've put a restriction on the account, but now the time is up and there's no more time to get. Well, then what do you do? Do you just keep the restriction and take the risk of getting sued? Do you let the money go and take what I think is probably the bigger risk of getting sued? It's very challenging, and ultimately getting the trusted contact. If there's a family member and there's something going on, most of the time that person's going to step up. They're going to seek a guardianship action. They're going to step in and say, hey, I have power of attorney and I'm going to take over this now. Mom or dad I took them to the doctor and they have diminished capacity. Someone is going to step up that is not the firm to deal with this issue, which is really how it should be. I mean, firms and advisors are not doctors. They're not in a position to determine, does somebody have capacity, or to determine, is this person susceptible to exploitation? Do they need someone taking care of their life decisions? That's really not the firm's function, nor are they really qualified to do that. What their function is in this space, and what they are qualified to do, is to raise a hand if they see red flags and say, hey, there's something going on here. So I can't stress enough how important it is to get the trusted contact and to really make an effort to get it from your clients. You won't always be able to do it, but the more effort you put into trying to get it, the more successful you're going to be.
So I 100% agree with Joelle. I think it's absolutely important to have a trusted contact person on an account. And I just wanted to add 2 more points to that. One is, there was a recent report released by, I think it was the Ontario Securities Commission, about behavioral techniques in order to encourage your clients to provide a trusted contact on account forms. And then you mentioned, Joelle, something about the amount of time it takes for APS to complete an investigation. So NAPSA had released some information recently, the National Adult Protective Services Organization, stating that the average APS investigation takes 52 days. And these investigations relating to financial exploitation are on the complex side. So they're going to be taking longer period of time than the average, potentially, investigation. But 100%.
Yeah, and there's a couple things I want to add to this. Like, from an investment advisor and a broker standpoint, you can really use this trusted contact person. It's a service to your customers. And you should be looking at it not from the view of, like Joelle mentioned, this is additional paperwork. It should be viewed as something that can set you apart from the other service providers. You're talking with them, you're educating them about what benefits this has. I mean, it's kind of like a insurance rider on an insurance plan, right? It's a little bit extra layer of protection, and it doesn't cost them anything. And as you're working with your clients as an investment advisor or broker, it's about building relationships. And this is a great tool for building relationships. It's never too early to get trusted contact information for your clients. So you've got somebody who's young, doesn't see the importance of it. Again, this is where you can come in and educate. And I think that education and that relationship just goes a long way for your clients. And
I think to that point, it's also. Oh, sorry. It's also about
interrupting real. Oh,
go ahead. Sorry.
Just giving our first CLE code. Our first CLE code is Bressler. Just go ahead, Joelle. Sorry.
Yeah, and I think the emphasis should be on preventing fraud in the account, as opposed to saying, in case you get diminished capacity and you have Alzheimer's. I mean, it's also the way that you kind of frame that. And then I also saw, I'll just answer this one question I saw come up real quick, in connection with a trusted contact. It was asked, are you expected to file a report of suspected exploitation, or is contacting the trusted contact person enough if they say they'll handle it? It depends on the state. You have to report. If you're in a mandatory reporting state, it doesn't matter who else you've spoken to, you must report. And frankly, I would say even if you're in a permissive state, you're probably going to be better off reporting it. Because if there is a perpetrator, for example, Well, the trusted contact might be a good resource to try and get that person away or to try and prevent the assets from leaving. You still have someone who's basically a criminal out there that the trusted contact is not able to do anything about. So you can check the map, see if you're required to report. If you are in a state with required reporting, absolutely you must report. Talking to the trusted contact is not enough if you believe that there is exploitation going on.
Yep.
Yeah, and I think, oh, go ahead.
No, I was just gonna move on. Sorry.
Yeah, and Rochelle mentioned it, but I think the most important thing here, or one of the most important things, is education, and it's education to the advisors about how important this is when they talk to their clients, and then it's the advisors educating the clients about how important this is, and how it can end up saving them, the wealth they've accumulated over the years. And those are difficult conversations. I mean, there's different techniques that can be used to have those conversations. Use of hypothetical scenarios, starting the conversation before the person gets older, so you have that trusted contact on file, and they don't feel like you're maybe attacking them for being older or having potential diminished capacity. The earlier you start those conversations, the better.
Yeah, so we've been getting a couple of questions. I just want to repeat one of the CLE codes is Bressler. So there was a couple questions on that. Let's talk about the temporary holds. This is from FINRA Rule 2165. The key takeaways here is the initial temporary hold is 15 days, and it's only a hold currently on suspicious disbursements, and that's disbursements of funds and securities only. So one, it doesn't apply to transactions at the FINRA level yet. They are collecting comments, and there may be a revision to expand this to include transactions, but at this moment, it's just limited to disbursements. And again, like I said, it's suspicious disbursement. So if you've got, if they normally pay nursing home fees, something like that, those should continue. They need to continue. You cannot place a hold on those, only the suspected fraud. And on that, I do have a question. Several states, have the laws permitting broker-dealers and IRAs to place holds on the transactions. So from the advisor or the broker-dealer perspective, Andrew, Joelle, what do you recommend as far as, do they follow state rule if the transaction is what's suspicious, or do they need to comply with the designated regulatory authority, FINRA?
So you really have to look at both bodies of law. So if there is a transaction that's at issue, if the transaction is suspicious, you suspect financial exploitation, you're not going to be able to do anything under FINRA rules. So you're going to have to look at the state law. If the state law allows it, that's great. You can place the hold for a limited amount of time, investigate it, either clear it or stop it for longer, request a court order. You can really take steps at that point, contact a third party, like we talked about earlier. For disbursements, you really have to follow, if you're a regulated broker-dealer, you really have to follow both FINRA rules and the applicable state law.
Okay. All right. The steps, go ahead, Andrew.
Nope, go ahead.
The steps for holds. The first thing is you have to have a reasonable belief that the financial exploitation is taking place or is about to take place. That's critical element. You really need to suspect financial exploitation. I believe Andrew touched on that before. You can't just rely on diminished capacity and think that this is a bad decision. The second thing that you're required to do for the holds is you have to provide notification to all the authorized parties who are allowed to transact business in the account, as well as the trusted contact persons. And you have to do that within 2 days. You have to notify them of the hold. And then immediately you need to begin your internal review. And documentation is key here. You want to document everything that you're finding, the basis for your rationale to place the hold, and that supports financial exploitation. Pending the results of your review, you may have an additional 10 business days at the FINRA level to extend the hold. And it's important to note that only compliance, legal, and supervisory personnel at the firm are entitled to place the hold. And that should be designated in the written procedures, which we'll talk about here in a second. So there are required procedures and required training under FINRA rule. So in your written supervisory procedures, you want to make sure that you're addressing how to identify. So we want red flags. We want to train on red flags. We want to address how we escalate issues when we do find them. And who's going to be doing the reporting and to whom are they going to be reporting? What order? Like we talked about, we want to be reporting to the state. We want to, if you're a broker dealer, you want to report to FINRA, advisors to the SEC. There's, again, this is the perfect place. And I always say in your WSPs, I have all my clients linked to the Bressler map, because that's like one of the things that you need to do once you're reporting, you know, and then to the state protective agencies. I previously mentioned you need to ID those authorized individuals who can place holds, who can terminate the holds and extend the holds. And then I think the critical part, we've talked about this, is training. You have to have policies and procedures on who gets trained, when they get trained, and how that training is going to be developed, what the content is going to be. So you want to train on red flags, you want to train on identification, escalation, everything that's written into your procedures. So hopefully that will help.
Oh, Rochelle, before you move on, the Washington State Attorney General's office has a sample PowerPoint on their website for training on this topic that firms are encouraged to use. It's the training that firms located in Washington are required to use, either that or something substantially similar. So that's a resource for firms if they're looking for a training, a sample training.
That's great.
Taking a look at the federal standards, and we've been talking about a lot of different laws and how they coalesce, if you will. I think the easiest takeaway from this is to recognize that in this particular space, the states have more stringent standards than the federal law. There is no SEC rule on point that specifically mentions, requires this type of reporting. However, that's swept up in the general supervision requirements, right? And we are seeing firms examined on ensuring that their policies and procedures under the Investment Advisors Act covers hot issues like this one. So it all comes together, but it tends to get more broad in terms of the requirements at the state level. So let's mention the Senior Safe Act, the federal law, which is permissive, right? It permits reporting by a firm, and in exchange for that report, so long as the firm has a reasonable basis to believe that something adverse is in effect or about to occur, and so long as that firm trains its employees on this particular topic, the firm will enjoy civil and administrative immunity, right, from any potential allegations with regard to disclosure of information from the client. So this federal law, it's terrific that it's there. It's from 2018. Some of the state laws have been in place, frankly, pre-Model Act. Some of the state laws have been in place in the APS, the Department of Welfare, the Department of Aging, whatever that state body is referred to as. Some of them have been there for years and years and years, right? Which requires, if you see abuse, you must report. All right, so the Senior Safe Act, I know it's a little confusing because we like to see a federal standard, some level of uniformity, et cetera, but there's a lot of action at the state level, right? If you're feeling a little confused and a little overwhelmed about all of these different reports, that's understandable when you're listening to this lecture. And fortunately, this Bressler map of state laws aligns everything for you, right? I use it, I work in this space, I use it all the time. I don't know the state laws, each state, which one requires training, where it could be a crime, right? It could be a crime in some states to fail to report abuse of another. In some jurisdictions, management, right? Attorneys, compliance officers actually are specifically called out and informed that they will be liable if they don't report, right? So each one is a little bit unique. I look them up every single time, right? Every single time. And again, this federal law is encompassing. It makes compliance with reporting at a voluntary or permissive level. You get something in return for doing that act. But as you will find, there are other jurisdictions and other regulators out there which will hold you even more accountable to report quickly, some within 48 hours. And again, you know, there can be criminal liability for failing to report. So the federal level, you know, talks about what you need to do in order to enjoy that immunity. It's somewhat of an umbrella rule or pardon me, statute that's in place at this juncture. But from my experience, I think the potential liability lies more from a regulatory perspective at the state level.
Yeah, absolutely. And I would just add, we had a comment to the comment I had made earlier about my experience with someone when I was speaking at the IAA conference, you know, saying, well, I just follow the senior safe because everything else is too confusing. And that particular regulator said that in his state, if you failed to report and said it's because you were just following the Senior Safe Act, you'd have problems with the state regulators. So, you know, Carolyn hit the nail on the head. You got to start at the state level. That's what's going to be the most have the most requirements typically, but also have the most benefits and give you the most ability to deal with this, particularly if you're in a state that allows you to reach out to third-party individuals like we talked about earlier.
If I could just add to that just for a second, at some point, you know, I'm hoping as a society, we all just say, you know, we see it, we spot it, we're reporting it. You know, this is like child abuse. This is like, you know, a public issue, you know, a public crisis. And we won't even be that concerned. If it all hits our conscience at a certain level, we won't worry about whether it's mandatory or permissive or, you know, these intricacies. We'll just be trained and our thought processes will be more aligned with simply reporting it, right? It's a different way to interface with clients than what we've been accustomed to in the past, where it's just been privacy, 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 and more privacy. You know, this is a little bit of a carve out to that, and people are getting used to it, I think.
We're running a little bit short on time, so Joelle, we'll probably move through FINRA Rule 3241. Joelle was actually part of a Bressler panel last week that did an hour on this topic. So if you're interested in hearing more about it, that's posted on our website. We have here, and I'll go through these quickly, but we have some helpful tools to recognize diminished capacity. A lot of these are fairly self-explanatory. And we also have some red flags that indicate some possible financial exploitation. And really the key takeaway, and we said it earlier, but 58% of financial exploitation is from family members. And adult children are actually the largest percentage of that. And a lot of times investors don't recognize these people as a risk. And when they do identify them as a risk, they're then embarrassed to say anything. So that really puts an extra, burden on the advisor to take a look at a situation and use these red flags amongst others to see if, you know, they think something suspicious is going on, and if they do, to escalate it, and for the firms to have clear escalation procedures and to have centralized reporting. If you're big enough, if you have enough people, centralized reporting groups where people who see this kind of stuff every day can really evaluate those red flags and determine if something's there or if it's not. Kristen, these are some exam topics that we've taken from FINRA's website. I wonder if you could tell us a little bit on the state level whether you see similar themes and similar priorities.
Definitely on the state level, we see similar themes. I'm just going to hit some high points because we're running short on time. But I think one of the major issues we see is the use of senior designations. So a lot of times people will come up with a credential that's not accredited that they're using. And that's one thing one of the things that we see the most often. I think the next thing, we'll look at the books and records, and if we notice that an individual doesn't have many clients or customers that have designated a trusted contact, we will ask them for their pitch. And sometimes when we get their pitch, we realize why there aren't a lot of trusted contacts designated, because I wouldn't give a trusted contact with that pitch either. So, working with them on the trusted contact, and then training and knowing what to do if they see financial exploitation. And always, we're here as a resource. I've heard that some firms are nervous about reporting financial exploitation, but I've never seen an enforcement case against a firm because they reported it, assuming that they weren't the individual exploiting the senior. So reach out to your state regulators when you have an issue. We're here to help you.
The final CLE code is harden. And we have Joelle. Can you talk a little bit quickly about the preventative measures that we've seen be effective?
Sure. So I think, as Andrew said, to the extent you can, centralize the reporting and the escalation. If you have one person who's in charge of doing this and who knows this stuff like the back of their hand, it's going to be a much easier process than if everybody's doing their own thing. Increase contact with older clients. Obviously, pre and post COVID times, try to lay eyes on them at least once a year, I'd say, if possible. Be vigilant with power of attorney and guardian accounts. I had a field training and even joint accounts as well. There can be exploitation in joint accounts. Just because someone has authority to do something in an account does not mean that they are not exploiting someone. And so POA and guardian accounts are where we see this a lot. There was a New Yorker article about a professional guardian out in Las Vegas who made a living out of basically exploiting older people. There's a movie now called I Care a Lot on Netflix that basically is kind of about that. If you haven't seen it, it's an interesting one to watch. But definitely be on the lookout for that sort of stuff. Another preventative measure is we've started to see some clients put in their customer account agreement a provision that allows them to place restrictions on the account if there is suspected fraud. To the extent you can do this, this is huge. This allows you a tool to use regardless of what state you're in, regardless of the Senior Safe Act, regardless of FINRA. If in the customer agreement it says, you authorize us to place a hold on your account if there is suspected fraud, that's another resource that you can use to try and address these issues. So I would also suggest that to firms if they're able to do that.
Just a quick point about that with Joelle. I think that's a great provision to have in your contract. Just make sure that it's narrowly tailored. Sometimes we see the provisions where it says we can lock down your account for an indefinite period of time if we suspect financial exploitation, and that kind of makes regulators a little bit nervous. So as narrow as you get the authority in the contract, but narrowly tailor it.
And Rochelle and Carolyn, from a compliance perspective, what do you see as we touched on a lot of them, but what do you see as some best practices to wrap us up today?
Yeah, real quick, I'll just say we've covered them all. You need those written supervisory procedures and they should be detailed. You need to include the Bressler map in those procedures. and the trusted contact person. Those are the 3 takeaways from today. I mean, if you don't do anything else, go do your WSPs, get those trusted contact persons, and consult them out.
Just to augment what Ro is talking about, I think working closely with your custodian and calling your liaison, if you use one of the major custodians, and speaking with them a little bit about what is your policy? How do you handle things? Let me make sure I'm informed as to what my business vendor is going to be doing on its side, and using that to help you customize your procedures that, as Ro has indicated, are just essential. I mean, absolutely essential at this point in time. I think it's also important to have the firm be comfortable with the policies and procedures. They have to be something that management is going to implement, right? And you have to have some level of consensus across your organization, whether it be big or small, because this issue is coming your way if it hasn't already. And be ready for it. You know, have a standard letter in place that you will issue to a client or to a household to keep them advised as to what is going on with their account. If there is a requirement in a particular rule, that you provide notice to the client about how long this situation will last. Have that letter ready. Understand who is going to be holding the account, who is going to be releasing the account, who is going to be filing, taking care of the filing requirements, and become the liaison perhaps during this difficult point in time. And if there's just one more takeaway for this, I also encourage firms through their training programs to kind of open it up to employees and say, okay, how would you describe this situation if there was a crisis with the client and we had to make a quick decision? What would you say, right? How would you explain what the firm was going to be doing, and put it into words that that firm feels comfortable with?
And with that, we are out of time. Thank you. Thanks to Hardin Compliance for co-hosting the webinar with us. Thanks to Joelle, Kristen, Rochelle, and Carolyn for speaking today. And I hope everyone has a great day.
Thank you, Andrew. Thank you, Joelle, Kristen.